Good morning again. My name is Niva Elkin-Koren. I'm the director of the Chief Justice Shamgar Center for Digital Law and Innovation. And it's a great pleasure to welcome you all today for our Freedom of Expression and Digital Platform one-day symposium. It's a great way to commemorate the legacy of Chief Justice Shamgar in this way, that a justice that have been committed to fundamental rights. This symposium is held in memory of Yoshua Rothenstreich, also a legendary attorney who was the head of the Israeli Bar Association and the president of the Israeli Press Council during the early days of the State of Israel. And we are grateful for the Rothenstreich family. Daniela is here for funding this event and for the ongoing collaboration and support. Social media has become our digital public sphere. It is where we express our opinions and preferences, where we acquire knowledge and updates on information, and most importantly, where we encounter other conflicting opinions, ideas, counter-argument, and at least in theory, that is where we can also convince others and change our opinions. Social media in this respect has failed us. As we have learned in liberal democracies over the past decades, so much has gone wrong in this ideal space of democratic deliberation. In Israel, we also received a vivid reminder over the past couple of months that democracy is not simply about voting. It is also about civic engagement in deliberation and action. And social media is definitely this place, virtual place, and the space where these take place. We all want to have freedom of speech online, but we often mean different things when we talk about freedom of expression. For absolutists like Elon Musk, for instance, who acquired Twitter in order to implement his ideology, absolutists would believe that free speech means safe environment where that free speech means it's free of any state or governmental interventions. Others believe that free speech means a safe environment where they can actually express themselves without any being affected by any offending speech or suffer from any emotional or intellectual harms. Countries also disagree on the meaning of freedom of speech and also on how to facilitate such freedom of expression on social media. So on one extreme, Texas, for instance, is advocating a law that would prohibit social media from any type of intervention in any content. In the other extreme, in the EU, we have a new law that actually require digital platforms to actively take action against different types of harmful speech. We don't only have different views about what free speech means, we also disagree on what would be the best way to incentivize platforms in order to do the right thing. This is a particularly interesting moment to engage in this type of conversation, and there are at least 3 reasons for that. One reason is that this is we are ending 3 decades after launching the internet, and it seems that the time has come for some legal reform. And therefore, we see around the world different types of reform initiatives after governments have been adopting hands-off policy toward the internet and social media. And so we see a lot of initiatives for reforming this type of situation. A second reason is a technological leap. The new generation of artificial intelligence, and especially generative models, language models and generative models in other contexts, once again create or introduce disruptive technology and create an interesting moment for transformation and change. If ChatGPT will become the main entry point to online information and to exchange and human interaction, social media and search engines may become outdated and obsolete. As lawyers and policymakers still focus on social media, emerging challenges might actually be somewhere else in the AI-human interaction. And maybe that is something that we'll tackle in our afternoon session that will focus on technological measures. A third reason why this is an interesting moment is political. Especially nowadays in Israel, we have a constitutional moment that actually requires us, among the many other challenges, to be very careful as we develop a regulatory framework. And this challenge might be relevant not only for Israel, but also to other liberal democracies. How to sustain checks and balances on governmental power, but at the same time to make sure that new technologies and new technological power embedded in social media or in other uprising technological or related players, how we make sure it works for the benefit of the public welfare and protect fundamental rights. We will explore some of these issues today, but before we move on to the program, some thank you or adieu. And first and foremost, this symposium could not have happened, especially in the short time we had to organize it, without two really great, dedicated, professional, enthusiastic women, Shelley Pasternak at the end, and Ayelet Crispin-Egozi. Extremely, extremely grateful to you. I want to also thank our partners, the Tel Aviv University Law Faculty, Tel Aviv University AI and Data Center, TAD, the Israeli Internet Association, the Ministry of Innovation, Science and Technology, and to thank our speakers that came from Israel and abroad, especially for this event, and to all of you that came early in the morning to Tel Aviv to join us and engage in this conversation. I'm confident we're going to have a great day, but before we start the program, let me invite Professor Avi Domb, the Chief Scientist of the Israeli Ministry of Innovation, Science and Technology, to share with us brief greetings.
Thank you very much. I think that you said it all, but I'll say a few words. Okay, good morning to the organizers, speakers, and respected audience for this important event on freedom of expression of digital platforms and the, I think, existing and next generation. Okay, the rapid technological development of digital platforms, artificial intelligence, and future computational systems, which I don't know yet, have a potential risk of breaching privacy and misconduct. There is a delicate balance between our desire to allow companies for further development, advanced computational technologies, and the protection of the people from misuse of these technologies. As a ministry that promotes applied science and translational research, we should consider this issue and help with the development of suitable means for keeping this balance, because companies will not develop a product if they are not secured that they can further sell it later on. Okay, the academia, regulations, regulatory bodies, and the legal system should deal with this dilemma and offer solutions. Wish you a pleasant day and an interesting seminar. Thank you.
So let me just invite Dr. Asaf Wiener, the Director of Research and Policy at the Israeli Internet Society, to run the first panel.
Thank you, Niva, and welcome all. I'm inviting our esteemed panel members, our first panel for today. We have an esteemed panel of experts who will share their insights on the complex relationship between free speech, digital platforms, and the evolving legal landscape. So we have here with us today Professor Kevin Werbach from the University of Pennsylvania, Professor Wolfgang Schulz from Leibniz Institute for Media Research, Professor Michael Geitz, Canada researcher in Internet and E-commerce law from Canada, and Liran Avisar Ben-Chorin, former Director General of the Ministry of Communication here in Israel. So just a word for the speakers. We all have rules and regulations, so presentation times will be carefully enforced. We'll take questions at the end of the panel. So without further ado, I'm inviting the first speaker, Professor Kevin Werbach, who will speak about platform regulation in America, the devils we don't know.
All right, thank you very much. Boker Tov, everyone. Very much a pleasure to be here. I'd like to give a little bit of context about what's happening in the United States on these issues. Just first of all, as I'm sure you know, America's in a particularly significant position. Maybe I'll stand up just so people can, I'm not sitting in front of the screen. The first important piece is just obviously most of the major global digital platforms, except for the ones that are based in China, are based in America, and we have a long history going back to the 1990s of internet policy and regulatory development in this area. But we also have at least two particular legal constructs that are very central to any of these discussions. The first one, of course, is the First Amendment, that we have a constitutional limitation on government involvement in speech, which puts certain constraints on the ability to create regulatory interventions with regard to free expression that are very relevant in this area. The second one is a piece of legislation that was adopted in 1996 called Section 230. It was originally part of something called the Communications Decency Act, which is ironic because the Communications Decency Act was an attempt by the US Congress to regulate speech on the internet. It was in fact a wildly overbroad attempt to regulate speech on the internet, to prohibit what was called, labeled indecent communication on the internet in the 1990s, was overturned by the courts on those constitutional grounds because it was unreasonably, excessively vague about what it would have prohibited, would have led to tremendous chilling of speech. However, there was a piece of that legislation which was incorporated into the larger 1996 Telecommunications Act, which was not invalidated, which remained in the law when the prohibitions were invalidated. And that was a set of protective or safe harbor provisions. Section 230 says that, and I put the operative words there on the slide, that online services, interactive computer services, an incredibly broad term that courts have found applies to basically any kind of internet service, are not treated as publishers, which in practice means they are not legally responsible for the statements of their users. There's a handful of exceptions. There's a separate law about copyright, does not apply to federal criminal law, but courts have read that incredibly broadly. And the motivation for that provision was that it's effectively impossible for a digital platform to have oversight over all the activities of their users. The model of publisher is a newspaper. A newspaper decides what they're going to print on the front page of the newspaper, so they can be held responsible for their editorial decision to print one story and not another story, and to put something in a story. But how does Google know what's in its search index? How does Facebook know everything that anyone is posting on Facebook? It would not make sense to say they are liable and they have to be responsible for pre-clearing every piece of information. This was now 30 years ago, almost 27 years ago, given the state of the internet then. That made sense. And obviously since then everything's exploded even more. But the problem is that's a very, very broad limitation. Section 230 has been read by the courts in dozens of different decisions in a way that very strongly limits any kind of action directly against the platform. And so that's been the source of controversy to some extent ever since 1996, but really in the last 10 to 15 years as social media has taken off. But the interesting thing is how the controversy has manifested itself. And so when I say that the devils we don't know, the reference point is the structure of the debate for at least the past decade in the US has been characterized by an interesting tension in that across the political spectrum, there is great unhappiness with this structure, with this Section 230 provision, but for different reasons. So broadly speaking, and of course I'm overgeneralizing here, the left is concerned that this leads to underfiltering, that because platforms have no incentive, they are not legally liable for what's on their platform, they don't take sufficient action against hate speech, harassment, other kinds of harmful content, misinformation. And so the push from the left is to narrow Section 230, to try and have more exceptions and more limits on what that protection is. On the other hand, the push from the right is exactly the opposite. The push from the right is a concern that there is too much filtering going on, a concern that the platforms are restricting the speech of conservative speakers, that they are shadow banning, deprioritizing speech that they don't like politically, because the executives of the major digital platforms tend to be more progressive, tend to donate to Democrats. And so the concern there is to want to push on the other side to force the platforms to do less in terms of their moderation of content. Now notice both sides are worried at some level about platform power. Both sides are concerned about the notion that these digital platforms have become the new public square. And that's something that of course has a tremendous resonance in the United States with this long history of First Amendment jurisprudence, but they're worried for different reasons. The left is more traditionally concerned about power in all of its forms. The right generally is much more deferential to corporations. In most of the other debates in the United States about, for example, network neutrality, the right, the Republicans, tend to want to give companies more freedom in their decisions. But here with the digital platforms, they want to restrict them more. So that has been the tension that we have had in the United States. There have been many, many proposals to scale back, eliminate Section 230, to adopt other kinds of rules for oversight of the digital platforms. Virtually all failed. There are 10 or 15 or 20 bills introduced in Congress almost every year. Almost none of them have passed. One passed a couple of years ago called Sesta Fosta that created a small carve out for basically sexual materials, sex trafficking activities, but fairly limited. But that's basically been the circumstance that we've been under, where this debate has raged to a great extent, but not that much has happened. So what I want to talk about is why that might be changing, and a few reasons. One is a political shift. We have largely a legislative stalemate in the United States because things are so narrowly split between the two parties, and the two parties have become so polarized in recent years that it's very difficult to get anything adopted, even where there's a consensus, even where both sides broadly agree. If the Democrats are in power, if they hold the presidency, the Republicans don't want them to get credit for passing legislation, and vice versa. So we have had that stalemate. But what's happened in the background is the courts in the United States have had a very strong rightward shift. During the Trump administration, they were able to appoint a large number of judges to the federal judiciary, a number of judges who have a fairly activist view about what they're doing. So courts have become more willing to take action against these companies on the more conservative direction. And the conservative legal movement in the United States has shifted broadly, of course I'm generalizing here, somewhat away from a very libertarian view towards this view of a need to take action in terms of imposing these restrictions on companies. So that's led to a series of challenges. There are two major cases that are pending right now. One is Gonzalez v. Google, and there's a parallel case against Twitter. This is a case challenging digital platforms. Both cases involve terrorist material online. Now, Section 230 would very clearly say just posting that material. One of your users posted something clearly illegal, clearly harmful. The platform's not responsible. It's not the platform's decision. The argument in Gonzalez is what's changed is algorithmic amplification. That because YouTube and Twitter now have algorithmic systems that are pushing this content to users, it's not just users searching for that content, it takes it out of Section 230. Case was argued in February before the Supreme Court, did not go very well for the plaintiffs that were arguing against the platforms, but suggested that the court is willing to consider these kinds of limits more strongly than they have been. Several of the conservative justices of the U.S. Supreme Court have expressed great skepticism in general about this Section 230 prohibition or prohibition on imposing rules on the platforms. At the same time, there are other cases that go the other direction. So the NetChoice case involves a law in Texas that would mandate that digital platforms be common carriers, that would say they can't moderate or filter anything. They have to post everything. That the platforms cannot restrict hate speech and misinformation and so forth. Coming from the conservative legislature in Texas, the Fifth Circuit, the appeals court in that part of the United States, upheld that law. The 11th Circuit in another part of the United States rejected a very much similar law. This case is also likely going up to the Supreme Court. So we may see a significant shift. There's also other legislation coming in many states in the US requiring age verification for adult sites and so forth. So it's very possible that we will see something that changes the dynamic in the US, that dramatically changes this scope of the protection. And then we'll see what happens. Then it may get pushed back to Congress to have to do something. But it's a different environment than what we've had. At the same time, other things are changing. One thing I didn't put on the slide because I'm focused here more on free expression is with regard to competition policy. The move in the United States under the Biden administration has been towards the left. With Lena Khan leading the Federal Trade Commission, the competition policy authorities in the United States have become more skeptical of big companies and big platforms taking action against Facebook and Google and so forth. So we're seeing that pressure ramping up at the same time as we're seeing in other areas things moving in the opposite direction. What's also happening is the environment is changing. Because of, for example, Apple's changes undermining behavioral targeting, which had a dramatic negative impact on Facebook's earnings. We're seeing potentially the advertising model of digital platforms, which has been so dominant for the past 10 to 15 years, being undermined. We are seeing changes in users, moving, for example, to TikTok for the first time, a non-US based platform. And we're seeing, of course, generative AI. ChatGPT being the first wedge that might actually undermine Google's dominance of search around the world. And more broadly, generative AI undermining the general sense of what does it mean to have user-generated content if the content's generated by a large learning model? What does it mean to moderate content if the content is algorithmically generated using one of these AI systems? These are questions we don't quite know how to answer. And then the final piece is this has become more of a geopolitical issue on two dimensions. One is vis-a-vis the United States and China, where China, of course, has its own digital platform ecosystem and blocks the major Western platforms. But China has become much more aggressive and more authoritarian domestically, and has become more aggressive in pushing digital sovereignty. The Chinese law should apply to activities that can be seen in China. And there they have gotten sympathy from the European Union, which has been willing to be in support of some ideas of digital sovereignty to push back against the major US-based platforms. There also now is some interest in the United States. So with Elon Musk taking over Twitter, Twitter is a company that for a long time has taken the view that they promote free speech, that their view is human rights, free speech is the right approach to take. And so therefore laws in different countries that they feel are restrictive on free expression, they don't want to follow them. Elon Musk's view is we should allow legal speech and prohibit illegal speech wherever it's illegal. So, for example, the Modi government in India has imposed restrictions on certain kinds of content, which in the past Twitter probably would have pushed back on. Now, in recent months, the Elon Musk Twitter has said, well, if India says it should be blocked, we're going to block it everywhere in the world, even to US-based users where the First Amendment would provide more expansive protections. So we're in this environment in the US. I don't know exactly where this is going to go. I just will wrap up with that. But the basic assumptions that we have, the structural features, Section 230 and the First Amendment are still there. The structural feature about the scope and power of these platforms is still there. But many of the assumptions that we've had in recent years that have structured this debate are very likely to be changing. So it's an interesting time, and it's an important time to have this kind of dialogue around the world. Thank you very much.
Thank you. I already list like a dozen of questions, but we'll leave that to the end. Now I wish to invite Professor Wolfgang Schulz to give us a look from the European view about platform regulation and digital services in general.
Yeah, hello everybody. The European perspective. I will not so much give you a broad overview of what's happening in the EU, but more zoom in on one element of one specific law that I find extremely interesting and will, I think, be part of the future of regulation in this field. We call this hybrid speech governance, and there is one clause in the DSA, the Digital Services Act in Europe, that is quite interesting in this respect. It does not go far enough. I will talk about that briefly, but it's a good start, I would say. Maybe at the beginning, what is the DSA? Most of you will have heard about that. The Digital Services Act has been enacted last year. It's coming into force step by step in Europe. It is a kind of regulation that is directly enforceable in all European states. So it's the new law that is governing the platforms. The basic concept is that you have different categories of platforms that basically are based on the size, the number of average monthly users, and the heavily regulated are the very large platforms and very large search engines that are those with more than 45 million average users per month, which is 10% of the EU population. That's why they took this number of 45 million. And they have the heaviest regulation here. The approach is that there has to be a mechanism to monitor illegal content and delete illegal content, and what is legal or not legal is basically governed by the member states. So Hungary and Germany and the others have their own standard what illegal content is, and the DSA requires the large platforms to have a mechanism in place that they can monitor and, if necessary, delete content that is illegal under Hungarian law, which might be a problem, and that's one of the criticisms that have been uttered, and I'm among the critics, I must confess. But now I want to focus on something which I find helpful within the DSA context, and that is that when we look at speech governance on platforms, then we have basically two sets of rules. We have private rules that are very often called community standards, and the basis of those is that you have a contract between the user and the platform, and this contract refers to rules how to behave on this platform and what kind of speech is allowed and not allowed. And you have the layer of state-set rules, of course, libel laws and others that govern the speech as well. this as such is not new. This a private university context, for example, what you can say on campus is governed by state laws, but it's also maybe part of the contract you as a student have with this university, and there might be some rules about how to behave on campus and what kind of speech is allowed on campus. However, I would say, and this little dog will help me to explain that, it's a little bit different on social media platforms, I would argue. And the argument is that when I like these kind of dogs, this is Germany very popular kind of small dog. If I want to have an online forum on these kind of dogs, then I have to have the capacity of setting rules to prohibit cat content on this platform, and I have to enforce this. Otherwise, it's not a small dog platform anymore. So the communication rule on the platform is part of the product. It's structuring the product. The communication rules are the product, you can argue in a way. So on social media platforms, this private speech rules are essential to make the platform what it actually is. If you want to analyze these governance structures on platforms, Balkan's triangle, many of you that study communication law will know it, is extremely helpful. So you have two lawmakers, the state and the platform. The state can act in different ways to regulate speech here. It can directly regulate user speech. It can indirectly, new school as Balkan calls it, regulate it in terms of regulating the platform to regulate the speech of the users. And you have this private rules I talked about, so my rules about cat content on my little dog platform. We are now increasingly interested in research in this interaction and overlapping of private regulation and state regulation. And we see more and more, and the DSA is an example of that, we see rules where the state law, for example, directly refers to this private regulation. It does not regulate the speech of the users. It does regulate how the companies regulate the speech on the platform. This field we call hybrid speech regulation, to give it a fancy name. We find it extremely interesting to see what different links you can find here between these fields of regulation. And if you look at it from a constitutional perspective, I will do that very, very briefly so that I can focus on the DSA here. You have basically three perspectives you can take. You can say, you can look at this hybrid order with the perspective of democratic legitimacy, for example. Is there the necessity to somehow back these rules, these private communication rules, because they are kind of hybrid, they are governing public speech, but they are also something people agree on a community. But other people are affected that are not on the platform, for example. Democracy might be affected. So do we need a kind of additional layer of democratic legitimacy for these kind of private rules that companies have there or not? You can talk about rule of law elements, and the DSA, as you will see, does that. And you have the fundamental rights element. Do platform have to observe fundamental rights of their users, for example? Has the lawmaker the obligation to force the platforms to observe the human rights, fundamental rights of the users? So when you look at the fundamental rights aspect, then a lot of very fundamental questions pop up, and each of those merit at least 2 PhDs, I would say, and some people in Germany and elsewhere are working on that already. Again, I will be very, very brief, just to give you a flavor of what I'm talking about. If you look at the state and the obligation to platform users, is there a duty to regulate platforms, for example? Under the German Constitution, where the Federal Constitutional Court has a tradition for broadcasting to interpret freedom of broadcasting in a way that it also entails the obligation to the lawmaker to regulate broadcasting, to protect the freedom of speech, something really foreigner thing to US thinking of fundamental rights. Is there something for platforms as well, can you come to the conclusion that there is this kind of duty? Another thing which is often overlooked, if you create some co-regulatory arrangements, is that a way where the state, the action a platform takes because there is a law, can be attributed to the state as an infringement of human rights, because the platforms only do it because of the law, attribution to the state. Is content moderation itself protected as speech, for example? I come to an example later on. And is there a duty to respect fundamental rights by the platforms? That's only a selection of very fundamental questions that you can have here. So, as I said, a little bit of a zoom in into one article of the DSA, which I believe is an interesting approach where the DSA embraces these hybridity, as we would call it. What does the DSA say? The DSA says here, providers of intermediary services shall act in a diligent, objective, and proportionate manner in applying and enforcing restrictions provided for in their terms of service, with due regards to rights and legitimate interests of all parties, and then the reference to the Charter of Fundamental Rights under the EU. Really interesting. In our sorting that I referred to already, all elements are somehow reflected in a way. So it's the terms of service, so we're thinking about contracts, but does this clause and the application of the source add a layer of legitimization because you are now acting under the DSA and so on? I just got the note that I just have 5 minutes left, so I leave it there. No, I don't. Because it's extremely important, this fundamental rights element over there, because there will be a lot of thinking and research about what that actually means for treating media content, for example. So we have a reference of protecting plurality under the Fundamental Rights Charter. What does that mean for a platform? Does that mean that they have to have special rules for dealing with media content, for example, because they have this media content has a specific role for public communication? And in that respect, we have before the DSA, but along the same lines, an extremely interesting and often overlooked decision by the Federal Court in Germany, not the Federal Constitutional Court, the Federal Court, where they apply the German doctrine of indirect effect of fundamental rights in a double way. They say when interpreting the terms of service of Facebook, the courts have to observe two things. First is the right to free speech of the user, but also they say content moderation is an exercise of free speech by Facebook. The setting those rules and applying those rules is protected under the German constitution. So the courts have a delicate balance to strike when they have this kind of cases. For example, someone's content has been deleted. He or she says, I want to put back. Contract says that content that is in compliance with the terms of service has to be published, and then when the courts decide about that, interpret the contract, they have to have this double binding with constitutional rights indirectly, which is highly interesting and complicated, and we will see some tests and dogmatic structures evolve now, what that actually means in practice. So very briefly, I think this kind of deliberation about indirectly governing the rulemaking of private actors does not only affect platforms and freedom of speech, it can be behavioral rules. If you think about the metaverse and where people in virtual worlds are interacting, then you can think what rules emerge there and what does that mean in terms of fundamental rights. You cannot only talk about freedom of speech, but also freedom of science, for example, of academic work. Does that mean that accounts cannot be deleted under the normal terms of service because I'm protected as a researcher? That's really a problem for empirically working people, that companies apply that. And finally, generative AI and when they train them to follow rules. This is a very recent set of rules that DeepMind, they invent a chatbot that is called Sparrow. That's the thing that competes with ChatGPT, and they train them with 23 rules. I would say completely arbitrary, but that's something to be considered as private rulemaking, and we might have an interest in saying, shouldn't that be influenced by fundamental rights, for example, and governed by fundamental rights, the setup of those rules and also the application of those rules. So, thanks very much for your attention. Looking forward to the debate later on.
And now we continue our tour around the globe, and I'm happy to invite Professor Michael Geist to share his perspective with us.
Great, thanks very much. As the slides are going up, thanks to Niva and the organizers for the invitation. It's so nice to see so many familiar faces and old friends here this morning. So things have changed a lot in Canada as well. About 6 years ago, actually, I think it was the last time I was in this classroom when I was visiting Prof. At the same time, on a different stage, we had our Prime Minister Justin Trudeau on a stage with Eric Schmidt from Google, talking and touting a new smart city project known as Sidewalk, which didn't come to fruition. The idea was that we were going to build as part of the front of Toronto's waterfront. I was actually on the chair of an advisory board to Waterfront Toronto that was looking at some of the privacy, security, and other kinds of implications of this. 6 years later, that just didn't come to fruition due to the opposition. In fact, if we fast forward 6 years later today, Facebook or Meta will appear before a House of Commons committee where members of Parliament will spend 2 hours asking why they're so evil or telling them why they're so evil. And in fact, even as part of this hearing, the committee has asked both Meta and Google for all internal correspondence and even all third-party correspondence dating back several years on any piece of government legislation. Frankly, I think it's an outrageous request. So too does the Canadian business community, which has objected. But it's a pretty big sea change from where the Prime Minister is taking the stage with Google and years later is demanding all internal correspondence from the company. So why this shift and where are we now in Canada? I think the shift is pretty self-evident. In Canada, it comes from both a cultural dimension as well as some of the kinds of harms that Niva was talking about off the top this morning. There was an attempt a number of years ago in Canada to think about how various platforms such as Netflix and others might contribute to Canadian culture. Minister walked away with a deal from the company to invest over 5 years in Canada. I think it was about a $500 million. They frankly invest far more than that, but that was widely panned. People saying that something more was needed beyond just that kind of investment. And then frankly, the events that we've seen, whether it's cyber attacks or the events in Christchurch, all had a pretty significant, I think, profound impact, quite frankly, on a lot of governments and certainly on the Canadian government, and represented a pretty significant change. So too, I have to say, was some of the personalization of some of the things that takes place. You know, I think members of Parliament, elected representatives, look at these issues oftentimes in the abstract and say, yeah, it's a problem. But when it affects their own, it takes on a particular resonance. And so, for example, this former cabinet minister, Catherine McKenna, was the subject of an enormous amount of online hate and misogyny. And when you speak to members of Parliament, frankly, from across the political spectrum, they often will reference what McKenna endured as evidence for why something needs to be done. All the other people who might have been affected, you know, that was a problem, but this really made it a problem. And suddenly there was a willingness to take action. What we've seen in Canada over the last several years is what I think is widely viewed as an internet legislative trilogy. I wanted to spend my few minutes talking a little bit about what we've done. And in fact, there is the hybrid model that we just heard about in one instance. The first piece of legislation deals with internet streamers. And the initial vision of this was really just to deal with the Netflixes and Disneys and Amazon Primes of the world. And it was thought to be the least controversial of what the government had in mind. The idea was to bring those internet streaming services into the Canadian broadcasting system requiring them to contribute in much the same way that conventional broadcasters might. This bill ended up taking up more than 2.5 years of debate. I'm in the midst of a joint course with the University of Haifa, and some of the students were amazed that anybody could spend 2.5 years debating whether or how much Netflix ought to contribute into a Canadian system. And the reason I think that this took off was not so much, and here's just a bit of a timeline, is not so much the Netflix side, but the fact that there were other streaming services, most notably user content services like TikTok and YouTube, that were ultimately scoped into this. And the question became far less about what a curated service like a Netflix or a Disney ought to contribute into the system, and more about the sort of hybrid speech model that we just heard about. To what extent would user content be treated in the same fashion as other kind of content from some of those sorts of regulated or curated services, and subject to potential regulation? So a very long timeline. This literally actually just passed through the Senate in the last couple of weeks. I appeared before House and Senate multiple times on this bill as it became incredibly politically charged. And the reason for that, there's just too much information on the slide, I'm sorry, but the reason for that is less about the mandated contributions, the idea that these services would be required to pay into a system, and more about the ways in which our broadcast regulator might seek to impose certain broadcast style regulations on user content. And so the Netflix, Amazon, Disney side, as I say, there are issues there, but it wasn't so interesting. What made this interesting, I think, was that after a number of months, the government made the decision to remove one of the exceptions related to users. When the bill was first introduced, the government had exempted both users as regulated entities, saying that they were not going to treat them as akin to a regulated broadcaster, and also saying that their content, the videos and other kinds of things that they might post on a TikTok or a YouTube, would also be exempted. The users continue to be exempted as regulated entities, but the exception for their content was removed. And so that kind of content then was subject to regulation. The line of the government was platforms in, users out, but consistent with the presentation that we just saw, effectively it meant that the platforms would be required to regulate that user content in certain ways. So the government was, in a sense, extending some of its regulatory priorities onto the platforms and by extension onto user content. That created an enormous amount of concern. The focal point of that regulation is what's known as discoverability rules, the idea that the government regulator or broadcast regulator could impose certain conditions on the platforms to prioritize certain kinds of content, Canadian content. As it happens, that's somewhat easier to identify where you're dealing with conventional large film and television productions. It's much different if you're dealing with a podcast or a TikToker or someone who posts content on YouTube. It's not even clear necessarily what would count as Canadian, much less how you might prioritize it, or even more, how you might how other kinds of content might in that same context be deprioritized. And the fear, consistent with Kevin's presentation, particularly from many on the right, was that they said, well, once the government gets involved in making some of these decisions around prioritizing or deprioritizing certain kinds of content, that surely the government, which is more of a center-left government in Canada, is going to ensure that content it favors becomes prioritized within some of those algorithms, and that other kinds of content, largely coming more from the right, would be more likely to be deprioritized. So there was a lot of concern around some of those issues with freedom of expression, questions about who would qualify and the like. The government has consistently sought to argue that that's not its intent. But yet the Senate, which would be our sort of chamber of sober second thought, which conducted the longest set of hearings on any bill in its history on this legislation. It's a little mind-blowing to think that that's what would happen. But they did, hearing from indigenous creators and a range of other kinds of creators who previously had really never spoken out politically, crafted an exemption that was designed to continue to ensure that the government met its use case. It said it was particularly concerned with sound recordings, wanting to ensure that a sound recording that would appear on, say, Spotify would be treated in an equivalent fashion if it appeared on YouTube. And so this would allow for that, but at the same time, scope out user content. And yet when it went back to the House of Commons, the government rejected that amendment, leading, I think, many to believe that at the end of the day, the intent is to have some of these powers, because the discoverability rules actually speaks more broadly to how programs are presented. And programs is any audiovisual content anywhere in the world, in fact. And so that kind of power suggests that the regulator could require warning labels on certain kinds of content or other kinds of indicia placed associated with that content, which is why this issue continued to play out. And at this stage, it's now passed as legislation. It will be up to the regulator to decide how it ultimately gets implemented. The second piece is an online news bill, which has also proven to be controversial, although not quite as controversial. It's modeled somewhat on the Australian model, the idea being that Canadian news organizations have struggled over the last number of years. Google and Facebook, notwithstanding some of the challenges they may begin to face in the online ad space, have been quite successful. I don't think that has a ton to do with the availability of news on their platforms, but nevertheless, the idea is they've done well, the news media has not done well, and so this effectively seeks to require payments from Google and Facebook in particular as what are called digital news intermediaries. They're required to first negotiate some sort of licensing agreement. If they're unable to reach an agreement, it would go to a final offer arbitration model in which both sides, media companies and two large platforms, would be required to put forward their best offer, so to speak. A panelist would decide what those happen to be. That has also proven to be very controversial. It is argued to be nothing more than compensating for the use of content, and who could disagree with that? But the definition of what use is in the legislation is not reproduction in full text of articles. Instead, it's pretty much any linking, indexing, or other kinds of uses that might exist. So it's access to the news or any portion of it facilitated by any means, including index, aggregation, or ranking. So essentially, it's mandated payments for links. Facebook, in an appearance before the Senate, Canadian Senate just last week, argued that about 90% of the news links that appear on their platform are posted by the news companies themselves. And this would require Facebook to pay for those links. I appeared before the Senate last week as well and suggested both that mandated payment for links was a significant problem, but so too was where the end game for this is. Canadian media companies have an expectation that as much as 35% of their news costs will be covered by these two companies. I'm not sure it creates a healthy ecosystem to be dependent to a third of your costs on two foreign Silicon Valley-based companies. But beyond that, both of those companies have said no way. And so Meta has said they will exit the Canadian news sector if this is passed, and they will block all news sharing. And they've been actually very, very consistent with that. They've said simply, it's not economic to pay $100 million or more a year simply for news links in Canada. It comprises about 3% of people's feeds. Google is in a somewhat more challenging space because it's not so much about people posting news as much as it is indexing it and the quality of search. And in fact, Google undertook an experiment, at first in secret, but it became apparent after a couple of weeks, where they stopped news links in their search engine in Canada for 4% of their users for a period of about a month. It took a few weeks for people to realize it, but then affected people began to recognize it. This became enormously controversial. That led to the demand for all Google internal communication and third-party communication. So there are some real questions about how they will ultimately respond, but their position at the moment is that they, in fact, they may stop news sharing as well. Finally, in my last minute, we also have an online harms bill, sometimes called an online safety bill. We actually don't have a bill yet, but this is designed to deal with hate speech and other kinds of content online. The government here too has struggled. It launched a series of consultations, largely cobbling together what is found in other countries. The NetzDG approach, the e-safety commissioner in Australia, they basically took together a grab bag of what is found around the world and say, hey, this is what we're going to do. It turned out about 90% of the respondents thought that the consultation was pretty bad. They refused to disclose the responses to that public consultation until I launched an access to information request, and they had to disclose that under ATIP. And it turned out that there was this widespread opposition. They have since launched an expert advisory panel, which is moving more towards a UK-style duty to act responsibly, but they haven't yet introduced that legislation yet. That's where they've been. Finally, in just my last 30 seconds or 20 seconds, just this weekend, just yesterday, the governing party, the Liberal Party, held a policy convention. And just to give you a sense of the temperature of where things are at least within this party, two of the policy resolutions, so this is not government policy, but it's party policy that often has a way to make it into their party platforms, were passed. One would require that online information services be accountable for the veracity of material published on their platforms and limit publication only to material whose sources can be traced, which has left many media companies really concerned about this notion of what do you do with unnamed sources or confidential sources. And so too with political advertising, seeking to create a new oversight body, they say at arm's length, that would examine the truthfulness of political advertising and be in a position to potentially take action. And these positions, as I say, not yet government policy, but reflective of where some of the debate is, at least within many in the governing party. I'll stop there.
One quick note before we move to our last speaker. All the legislation which were mentioned here for our Hebrew-speaking guest, I'll share in the break our digital observatory of the Israeli Internet Association, which list and analyze all those legislations and bills. So for the Hebrew-speaking audience, it might be useful. So now it is my honor to invite Liran Avisar Ben-Chorin, the legendary, I think, former Director General of the Israeli Ministry of Communication.
So Asaf, thank you. Good morning. Good to be here. Last time I've been here, I guess I was a student in this class. So I finished my role as the Director General of the Ministry of Communication months ago or so. And I'm going to give you a glance into the Israeli journey. It's short enough, so 10 minutes will be good. And it's coming from a regulatory point of view. So I was a regulator, and a year and a half or so, the Minister of Communication, the previous one, put together a committee comprised of academics, professors, and experts on the field to try and come up with a framework for regulation of social media platforms in Israel. I must say that it has to do with the fact that every few months there is a private legislation, you know, it pops up here and again. It mainly comes from the angle of user protection, user consumer regulation. That's the easiest angle for politicians to deal with the issue. And we thought it's a good idea to come up with a more holistic and deep legislation from the government side rather than deal with private draft legislation every few months. We're following what's happening around the world, in particular in Europe, in Canada, in Australia. And I'll take you through our journey and our main recommendation. I must say that you've all noticed that there was a change in administration lately. So the Minister of Communication, the previous one, actually adopted our recommendation. And now it's on the table. It has to do with the left-right and right-wing approach to the issue. So I can't say for sure it's going to become a legislation in Israel, but we're definitely on the road. I think we can't avoid this anymore. I think everyone understands this. It's a question of what's going to be the scope. So first of all, I must say it's a limited scope. It's not a DSA. It's all about dissemination of harmful content online and protection of users' fundamental rights. That's the issues we were dealing with. And I want to share with you the committee's premises. You know, a regulator, when it comes to make an intervention in the market, especially in our market, has to have a good justification. Why do you put regulation in an area where there is no regulation? So for us, the two main issues were that we rejected the claim of the SMPs that we were speaking to, that they don't manage their content. Like, we are kind of a bulletin board. We believe that they manage the content as long as they can suspend an account, recommend the specific content, amplify specific content, they manage their account, they manage the content. And the consequences is that they have to be held responsible for the content they disseminate to the public, and have to conduct themselves in a manner that limits content that is harmful to the Israeli society. I think that's the very basic assumption we've started from. And the other one is that we held the SMPs as a dual essence entities. It has to do with the impact they have on fundamental rights, on the Israeli society. It has also to do with the fact that it's pretty much a concentrated market. You know, that the telecommunication market in Israel is very sophisticated, very competitive. This market, due to decisions that were taken by other regulators, mainly in the United States, is very concentrated market, and it's part of the reason that we believe that intervention is needed here. So a few words about our basic principles. We'll start with the fact that we wanted to avoid excess regulation. In general, we want to avoid excess regulation. We just want to be where we need to be. And we look into the outcome, a kind of regulation that is outcome oriented. Okay, we don't know better than the SMPs how to get to the result. So we want to say that's the result we hope for. You'll do whatever you need to do in order to get there. The other issue is that we wanted to stick as much as possible to the trends, mainly the DSA. It's a small market. Israel is a very small market. Those are huge, giant international players, and we thought it's going to be better for everyone to stick as much as possible to the DSA. We got a good support from the European Union on this, and came up, and we only made changes where we felt that we have unique issues that has to do with the Israeli society that needs to be taken care of. So the biggest issue of this panel in general was to ensure the protection of freedom of expression. That was the main controversial issue in our committee. And I think we had to answer two questions. The most complicated question for us is, what's harmful content that is subjected to regulation? That's really the big issue. You know, we spend a lot of time on this issue. How do you classify content that should be subjected to regulation? It has to do with the question of how do you protect the freedom of speech. That is very sensitive in general, particularly in Israel these days, but in general. So we looked into three different options. One of them is that the DSA took actually is an illegal content. Illegal content shouldn't be out there disseminated through the via those platforms. The other one was harmful content, okay, including awful but lawful. And the third one was the option to say that content that violates SMP's community guidelines will be subjected to regulation. So the third option was taken off the table because we believed it's going to direct the SMPs to change and limit very much their community guidelines. The chosen classification is very conservative in my mind, although I support it after a lot of discussion on the issue. And we choose to look into the overlap piece in this circle. Illegal content, which is also harmful content. Why it is so conservative, basically? Think about it. It takes off, for example, disinformation. It takes off the table bullying, which I was very sensitive to. So we're not dealing with bullying now. It takes off copyright infringement. Okay, it's illegal, but it's not harmful necessary. So it's pretty conservative, but we felt that that's the right balance when we deal with the freedom of expression. When I think about digital platforms, basically the main issue is that it gives the unheard a voice And that makes it a lot more sensitive for us when we want to subject when we want to subject content to regulation. So more than that, we want to know what's illegal. All illegal content is part of this. We decided to have a list, actually in the legislation, a clear list of what illegal content considered to be subjected to regulation when it's illegal and harmful. And we're speaking about a list. That list can change, you know, legislation process is a long one, but we spoke about violence, racism, sexual harassment, threats, this kind of content, and we hope to have a closed list of legislation that is going to be subject to regulation as long as it is harmful. We did give a special treat to sexual content and targeting minors, as long as it's illegal and harmful, but only in terms of more stricter time constraints for taking action from the SMP's point of view. So that was the solution that we gave to this complicated question. And then the second big question is which entities are going to be subjected to regulation. And here we chose to go, first of all, with those who have significant impact on Israelis. I'm starting with the second one, those who have active that are exceeding 5% of the Israeli population. I think we've learned it from the DSA in a way. We didn't want to put a big burden on small players. It's not a good idea, never. You know, big players know how to deal with regulation. They have money, they have lawyers, they know what to do with it. Small players, it might avoid them from growing. So we want to let small players grow, and we want to be where the issue is really significant and the SMPs have huge impact in Israel. The other issue was we didn't want to put our hand on players that are not relevant to the bad effect that SMPs has. And that's why we chose a very limited definition. Content that is disseminated to the public, disseminated to the broad public, the content is generated by user, and where you have a recommendation system. So WhatsApp, for example, if you can see, is out of this definition. So once we finished those two big questions, we move to the toolkit. What do we suggest? How do we suggest to deal with harmful content? So the first and major recommendation is to impose liability on SMPs. And in which cases? In case that we have clear-cut classification, okay, it's illegal and harmful, okay, part of the list of what is illegal, then that they had awareness. Okay, we want to make sure that they actually knew about this content. It might be that they know from their monitoring systems. It might be that they got a notice from a user, from a third party, but they have to be aware. And the third one is that they didn't take a serious action. And here I want to make it clear. They don't necessarily have to take off the content, right? We didn't want to make them take off content too easily. They have to address the issue and to deal with it in a serious manner. And in this case, if they didn't do that, if they didn't meet all these three conditions, in this case, they might be held liable to the content. The other issue, judicial decrees to act with regards to specific content. As you all know, different cases are already we have different court decisions, and different cases are currently in the court. We want it to be clear. We want it to be clear. You know, there is a big discussion in Israel on the authority and the jurisdiction of our judicial system in general. Things have to be clear. So we want judges and the legal system in Israel to have the jurisdiction to deal with the issue, and judges to be able to put forth judicial decrees to remove content, for example. The third one was notice and action mechanism. We want to make sure that someone who was offended by, it might be a business, it might be just one of us, can actually speak with someone and get some serious response. You know, not you violated rule number 3A, C, D section, but a reasoning, a reasonable reasoning. And then we wanted to adopt the trusted flaggers mechanism. If you know this mechanism, it speaks about organization experts that are actually get priority. They monitor, they monitor the platforms, and they get priority in the way that the SMPs treat their notice and messages. And then that's the number 14, the Act 14, general requirement to limit access to illegal, harmful content. You know, some people in the community say, what do you mean? What does it mean, general requirement to limit access to illegal, harmful content? I think in a way it has to do with our assumption that they're going to be held responsible and that they have to act in accordance with principles that are stemming out of the administrative law. Fairness, equality, reasonability. Once you held them to be dual essence bodies, entities, then that's what you expect from them to do. Let's say a word about user empowerment. As I said, that's the easiest piece for politicians to deal with. You know, it's kind of consumer regulation. If you put a restriction on our account, we hear it a lot from politicians, especially right on the right side. We want to know. You want to know, let me know that you did it. Let me know why you did it. A reasoning, a detailed reasoning. Let me know, you know, who initiated this idea. Maybe it's a competitor that want to close my business. Accessibility and transparency on the guidelines, mainly when it gets to the freedom of speech. What's the forbidden content? What's the reasons for restricting an account? An appeal system. We want it to be dual-staged appeal. We want you to respond in a timely manner. We want it to be user-friendly. By the way, a question that we had, can we get this service in Hebrew? Do you monitor in Hebrew? Those are big questions for a small market, a small country, when it deals with harmful content that impacts its society. That's definitely part of our recommendation, that if you are a big player in Israel, a significant player, we want it to be in Hebrew. We want you to find a way to monitor in Hebrew and to give us a service in Hebrew. So I relate to the question of transparency, which was very significant to our committee. One of the issues is that when we met with the SMPs, we couldn't get data. We wanted to know how many subscribers you have. What are the most sensitive issues in Israel? Is it terrorism? Is it sexual harassment? What is it? We couldn't get data. So all the answers are that it's an aggregated data. Government that wants to deal with challenges online, which become significant, more and more significant. When you have air pollution, you can measure it, right? You know who caused it, and you can put out the regulation. Here, you don't have any information. So one big issue for us is to get data from the SMPs about the users in Israel, about the scope of harmful content that is accessible to users in Israel, about restriction imposed by SMPs on users in Israel. And more than that, we wanted to know what's the mechanism employed by the SMPs to combat harmful content, specifically to harmful content in Israel and not generally what they do around the world. Ken, Mam Tzavi? I'm good? Okay. So I'll skip the risk management, not so important, but here again, we want you to assess the risk in Israel, not in general, not all over the world. Every country has its own issues. We want to know what's the risk assessment in Israel and what's the best practices that you use in order to mitigate those. I'll finish with the fact that we believe that we have to have a regulator that will deal with the issue. We believe it might be the same regulator that deals with radio and with broadcast channels. You know, it's a very dramatic discussion, but same dramatic discussion took place when we spoke back then about the radio and about broadcasters. Today it doesn't make sense to any of us that someone will come on the radio and encourage violence, right? Online, it makes sense now. It shouldn't make sense, I believe, as well. So we'll finish with this. We want to make sure that there is jurisdiction for the Israeli system on those issues, given the fact that those are international companies that placed out of Israel. That became a question. And we wanted to make sure that, you know, an Israeli user can choose the Israeli law as the choice of law as part of balancing the power between the big players and the users. I'll finish with that, sharing with you that I don't know how it's going to unfold and if it's going to become a legislation. It depends on how things in general in Israel are going to unfold. I believe that this sensitive issue became part of the big issues that we're dealing with at this time. It has to do with it in a very delicate way. So we'll have to wait and see. But I feel that we paved the way with putting out there a formal framework for the first time, a governmental framework for this. And I think we're not going to have the ability to stay away from the issue at the coming year or two. So thank you so much.
So I'd like to use my privilege as the host of this panel to begin with a question to each of you. And I have two questions. One is very constitutional theory of free speech, and one is more practical. I think you all talked about protecting also the fundamental rights of the platforms, and even specifically in the US, talking about First Amendment considerations. And I wanted to ask, on the theoretical level, we see some ideas that big platforms, big players, loud players who can amplify or mute other speakers might not be eligible for the full protection of the First Amendment. In Europe, I think it may even be more easy, since the free speech is not as rigid as the First Amendment. So this is one question. Do we really want to think about the free speech rights of platforms, especially the big international wealthy platforms, as we think about the fundamental rights and free speech of users? That's the theoretical one. And the practical is about the regulator. We all talked about regulation and new laws, and I think I would like to hear from each of you. What do you think about the nature, the scope, or the structure of this regulator? We know the DSA is building upon a very wealthy, well-professional regulator to check the companies to see if they apply the rules and specifically the technical instructions. Also in the US, we have the FTC, so it's maybe consumerism or maybe competition. So the identity of the super regulator is something that I would like to hear your opinions on.
Sure.
And if anyone in the crowd wants to have a question, please raise your hands and I will get to you.
Sure, thank you. So those are very big questions. So let me try to answer briefly. On the theoretical point, I'm not a First Amendment scholar per se, but this broad question about the scope to which free speech rights protect those of corporations versus those of individuals is something that's been a source of a great deal of debate and controversy in the United States in recent years, most famously the Citizens United decision, which suggested that corporations' free speech rights would be limited if they were not able to make direct contributions to influence political campaigns. It has really accelerated this debate about the implications of the First Amendment on corporations. And I guess I would broadly say we're going through a significant theoretical debate about what those provisions should be. And so, for example, I have a colleague in my department, Amanda Shanor, who does work on this issue about corporate speech and has argued in other contexts that we need to go back to what are the goals of the First Amendment, that more broadly, it's about access to information and access to public life. And so therefore, if we think about economic liberty, the regulations with regard to corporations should be ones that are consistent with the goals of the First Amendment, as opposed to just a very doctrinaire, narrow reading of it. So broadly speaking, the answer to your question is yes. That is a difficult issue we are starting to struggle with in the U.S., the rights of individuals versus the rights of the platforms. But it's part of a larger debate that is, I think, now we're starting to see some good theoretical contributions too, but it's really distinct from the way First Amendment jurisprudence has been thought of before. On the practical question, a number of experts have proposed a new digital platform super regulator in the U.S. It's a very good idea. It's not going to happen anytime soon because, as I suggested before, almost nothing is going to happen from the legislature in the U.S. anytime soon. But it's possible. The problem we have is that, as you say, the Federal Trade Commission is a quasi-competition regulator, a quasi-consumer regulator. We have other competition regulators like the Antitrust Division of the Department of Justice. We also have the Federal Communications Commission, which is the Media and Communications and Telecommunications regulator, which was not really set up for this, but has the technical expertise and background and has dealt with some similar kinds of issues. None of them really have either the legal authority or the competency to deal with the full scope of all these issues. So they are doing what they can. The FTC, just because of its structure, is acting more now. The FCC is now deadlocked because there are 2 Democratic and 2 Republican commissioners. President Biden nominated a wonderful good friend of mine named Gigi Sohn to be the 3rd Democratic commissioner. She never got a vote in the Senate. It was blocked by lobbying from basically the media and communications industries. So the FCC right now is just not in a position to do much of anything significant. So that just goes back to, I hate to keep pulling it into local politics, but that very much underlies what's happening in the United States today.
Sure. So, I mean, well, on the constitutional issues in Canada, there are 2. One is some of the charter rights and freedoms issues in Canada. Canada's approach to freedom of expression is subject to a notwithstanding clause. It's sometimes actually, I believe, raised as part of the debates here. In Israel, I think somewhat misleadingly in terms of the protections that we have in Canada, which are still quite strong. But I think the more concentrated debate around constitutionality in Canada is actually a division of powers issue between our federal government and our provinces. Because a number of these issues really, property and civil rights falls to the provinces. And many of these issues feel like they are more properly set within provincial jurisdiction. Federal government is seeking to assert jurisdiction on the grounds, in effect, that the internet cuts across boundaries, of course, and so it has a role to play. But taken to its limit, given that the internet has such an impact on just about every aspect of society, it effectively would represent almost a complete federal assertion over jurisdiction over just about everything over the provinces. And we have several provinces in Canada, notably Quebec, one side of the country, Alberta on another, that are very protective, zealously safeguard provincial powers. And so I suspect on some of these issues, they may end up before our Supreme Court, potentially on charter grounds, depending on some of the way some of the expression stuff plays out, but potentially even more as to whether or not the very premise that the federal government has the power, for example, to regulate the news sector in the way that I described under Bill C-18, I think is certainly an open question. As for the regulator, it falls to our broadcast regulator at the moment, and that's almost just by default. There isn't another obvious place to go. But our regulator, I believe, does not have the institutional expertise or capacity to deal with a number of these kinds of issues. But I think even more problematically, it is an entity that has been subject to regulatory capture for a very long time. There's just a revolving door between the conventionally regulated sector, the broadcasters in particular, and the regulator itself. And I think there's reason for significant concern about how individual rights in particular arising out of some of these issues will be represented. This notion that TikTokers or YouTubers are suddenly going to show up in Gatineau, Quebec, which is where the regulator is located, to begin to advocate for their rights in terms of their content being either amplified or de-amplified, I think is fiction. I mean, they're just not going to do it. And to the extent to which they do, they just don't have anywhere near the kind of capacity that conventional players do. It creates an incredibly unlevel playing field, and I think is a significant cause for concern given how the legislation is envisioned in terms of playing out from an administrative and regulatory perspective.
Maybe just if that works. I talked a little bit already about the fundamental rights issue. I think under the German concept of horizontal application of fundamental rights, Drittwirkung as it is called in German, it's not so much of a problem because you can have both. You can have these kind of horizontal binding of the platforms, but they can also be entitled to under human rights concept. So I think that's the beauty of this kind of concept, that you can deal with that. The German Federal Constitutional Court actually played with the notion, they have not decided on that already, whether there could be two levels of binding for platforms you really depend on, the big platforms. It could be a stricter binding to, even state-like binding to fundamental rights, which is an interesting idea. But then, of course, the question would be what are the criteria for these kind of dependence on the service? And they have not elaborated on that so far. In terms of the right regulator, I think something we should keep in mind is the old saying translated from Latin, who watches the watchers. The European Commission under the DSA is the main regulator for the big platforms. And I have some concerns, to be frank, about how they will act and their independence. That is one thing when you think about regulators, it's independence. The second one is knowledge. How do they get the knowledge they need to regulate here? And that's not an easy one. In Germany, we had some discussions about which regulator should be the coordinator, as it is called, the national coordinator, as it is called, under the DSA framework. The state media authorities responsible for broadcasting regulation wanted the job, but finally the telecom regulator got it. And they are now forming an internal independent body within the regulator that fulfills the role of the coordinator under the DSA. So the law is to be published, I think, next week or something, where the federal government lays out all the details how Germany will deal with the DSA in terms of competencies.
So I'll be short. Everyone are worried about the regulator. But I don't have a better alternative than put out the regulator. So the big two question you already iterated at, independency from the government and expertise. We thought it might be a new body or it might be the current body, but it also needs to develop new expertise. Also, although it deals with content today, there are a lot of differences. And we think that's the only way to deal with the issue is to put out the regulator that is independent with public counsel, with representative from the public. And I believe that's the way to go.
Any questions from the audience?
So the question is about the mechanism of spreading the content. So the platforms have their own community rules about fake profiles and coordinated inauthentic behavior. But they don't always following their own rules. We still see fake accounts and coordinated inauthentic behavior. So how do you see the freedom of speech of fake users, bots, and stuff like that that spreads legal content, but still push narratives? And how do you think you should regulate and protect the public from coordinated inauthentic behavior?
It's an excellent question because we are all in academia and practice very much focused on content moderation, not so much on behavior. So there are, as you say, very differentiated rules. So Meta, for example, differentiates between inauthentic behavior and coordinated inauthentic behavior with different set of rules coming with that. And as far as I see it, I'm not sure how you perceive it, the lawmaker does not really have that in their view. They're very much thinking about content and harmful content and not so much about behavior. So that's definitely, as far as I observe, the lawmaking process in Europe hasn't really played a role. And so these Article 14 I'm having been looking at is also focusing on content. And one thing we actually, when we now interpret the law, is can we somehow interpret it in a way that the rules about inauthentic behavior or coordinated inauthentic behavior is covered as well. But since the lawmaker did not really see it, it's doubtful whether that's applicable.
I'll just add to the question that we now in Israel had a proposed bill for a bot legislation which mandate bots or automated conduct to give notice or disclosure about this. It didn't pass as a law, but it's also something I think very effective to think about the speakers and inauthentic rather than to try to find all the harm content. I saw a question over there.
Just I interrupt. The prerogative of having the mic. Question about public advocacy. You talked about, it seems from your conversation, it seems that we just don't understand what's the problem. We don't, as in individuals, as an public officials, and we get it only when it strikes home. So the Canadian politician, just when she saw her information spread, and you said in the US about liberals and conservatives, I was reminded of Justice Scalia. So what's privacy? There's no privacy if you have nothing to hide. And then once there was like a project like, okay, this is dear Justice Scalia, here is all your information, and that clicked. So how these are very important discussions, but how can we get it a step forward?
Well, in theory, that should be the institutional design question. That's why you have, say, an expert regulator or some institutional structure that can be abstracted and can judge when it's just a personal consideration or a kind of sectoral consideration versus one that should drive legislation. But yes, it's human nature. And in the United States, the coordinated misinformation and disinformation campaigns, many from overseas, in the 2016 election was a big driver of a lot of the activity. And that should that have been, well, it was certainly important and woke up a lot of people to issues. But the problem, of course, is it's now these social media platforms which are what disseminate the information. And to the extent that people see a problem being a big problem, it's often through the same kind of amplification processes. So yeah, I don't think there's any way to get away from that human dynamic, but structurally the system should be set up in a way that the decision making is on some principles and through some administrative process that doesn't get driven that way.
If I can just continue, I know there's a few questions. I have to say one of the challenges that I think we've observed in Canada is that we do get individuals who previously were not politically active engaging on some of these issues, but some of the same kinds of really problematic speech that seems to arise that might target politicians target those individuals as well. So in the context of C11, there were a number of TikTokers, for example, that did speak out expressing concern that their voice might be harmed and affect the ability for people to find them. And they were targeted again, the same sort of back and forth that took place. Over the weekend, I was called on Twitter a traitor. I've had members of parliament call me a racist, coming out of some of these sorts of things. I think I'm neither a traitor nor a racist, just for the record. But that's the sort of stuff that arises. And for a lot of people that never took the time to engage, but this does resonate in a certain way, I can tell you they are likely never to engage again. That they speak out once, they found that they were targeted, and they say this just isn't worth it.
So just we'll take all the questions, and then we'll give the panel last chance to answer from the stage at least.
Thank you very much. So my question is regarding fines and other sanctions that are imposed on digital platforms. And we know from privacy regulation that fines that regulatory bodies and supervisory authorities impose substantially large fines on companies. But although these, in terms of normal people's money, these are very large amounts. In terms of companies like huge companies like Google and Meta, etc., these are amounts that they can afford to pay, and eventually this becomes part of the cost of doing business. They pay these fines. Some of these they pay, others they're trying to fight. But at the end of the day, these not necessarily deter them from or make them comply the law. So how do you think governments and regulatory bodies should address this in regarding regulation on digital platforms?
Okay, well, so I'll take the fines one then. So its question is not so much the amount of the fine, but it's that relative to the business benefit of the practice. So sort of, for example, to Professor Geist's point about the news linking, the question was how much benefit did these companies do from this activity? With regard to privacy, the targeted advertising market is so core to those companies' business model that a very large fine indeed is still worth paying. So that's why a lot of the debate, including in the United States, has moved more towards direct conduct regulation to actually imposing obligations with oversight mechanisms beyond just financial ones. But it really has to be a more fine-grained conversation. There's some of the areas that we're talking about where a fine and economic incentive can have a very dramatic effect. Because the company says, why do I care? It's not so important to me to be doing this practice. In other cases, then as you say, for those very large companies, the fine is insignificant. The other thing I'll say is, we tend to always gravitate towards focusing just on Google and Meta and maybe a few of the others to some extent. But in some cases, these rules, as we heard, have spillover effects on smaller platforms, user-generated platforms, where even a relatively small fine can have a big impact. So it's really impossible to have one answer to that question.
Sure. So first on the Canadian content question. So there's really two questions actually. First, what even counts as Canadian content? And we have established rules in that regard for conventional film and television production, as well as music, sound recordings. It's an imperfect system. And part of that is that there are several policy goals, none of which are perfectly met. So sometimes it's about so-called telling Canadian stories, whatever that means. Sometimes it's about just purely economics, trying to have more Canadians hired. And sometimes it's about the intellectual property, who owns it. And so you get things that are considered Canadian content. There's a documentary called Gotta Love Trump, which counts as Canadian content because it ticked the right boxes, but there's no real Canadian connection there, and Trump isn't much loved in Canada. On the other hand, there are assortment of productions that feel pretty Canadian. Disney's Turning Red, assortment of other productions that seem pretty Canadian, but they're not because they're owned by Netflix and the like. In terms of how much, that's a good question. We have rules for radio. We have rules for television. We do not have rules for the internet. And I don't think we will get content quotas in that regard either. I think it is more likely to be about finding different ways to amplify Canadian content, so at least it's more visible, as opposed to creating a specific percentage. So in your Netflix recommendation bar, you could envision sort of something along the lines of, here's some great Canadian content that you might want to watch. Now, the reality is that Netflix and otherwise, if you happen to watch Canadian content, they're going to recommend more Canadian content in the same way that if you watch Squid Game, you're going to get a bunch more Korean programs. So they already do that to a certain extent, but this will create some sort of mandates. How they do it if they do it for TikTok or YouTube, nobody knows. As far as I know, there is no country that has attempted to try to do this, and it's many arguments against it for some of those reasons were unfortunately unsuccessful.
Briefly on the fines, from a European perspective, I think maybe two aspects. The first one is the European Union found this clever way to do not have fixed limit of fines, but say that it's a percentage of the global turnover, and with the DSA it's 6%, and that is something even for big companies that is substantial. But secondly, I think for big companies, the market size is what matters. When the EU comes up with some rules, then the market is big enough that they say we have to set up a compliance mechanism there. And that's not because of the fines, but it's because the market is so big and won't want to have trouble there. A colleague of mine, a former colleague of mine, is now a member of the Broadcasting and Communications Commission in Thailand, and she has really problems because the market seems not big enough to find people to talk with in terms of compliance mechanisms in Thailand. So it really makes a difference.
So in many ways you describe our challenge. Israel is a small market. You know, it might be cheaper to pay the fine rather than to deploy a cellular infrastructure in the north, right? So we believe that you have to start with strong competition. That's the name of the game before you get to the sanction. A lot of players that runs one against each other. Also in this field, it's true. If you have more competition, then you can make better choices. Then I want to tell you that transparency is a second issue. If they have to show everyone how they act, what are their best practices to mitigate harmful content, then everyone can see and everyone can make better choices. And third, you have to understand that fine is damaging the brand. It's not just the fine, it's their brand. I said in Israel, in the telecommunication market, they feel very uncomfortable about big fines that out there in the internet and on the newspapers. It damages their brand and might make people choose their competitors. So those are the two we have, and I do believe in big fines, but in a small country like Israel, you can't really have huge fines like you see in Europe and in the United States.
So thank you, everyone. We have to finish to give people some time to breathe and drink coffee before our next session. A few notices: if someone is intending to come to our lunch today, please make sure you're on the list, which is circulating around here. And we'll take a 20 minutes break, so I think we can be back here by 12:10. So thank you again, all the participants.